Hello, welcome to another episode of the 10-Minute Land Surveyor. I'm Dave Woolley. Today we're going to be talking about legal theories, property rights, and the role of a land surveyor. Property is the single largest asset that most Americans will ever have, and a lot of wealth is built in the real estate. So to say that property rights are important to the land surveyor, important to American society is an understatement. I'll recommend some reading. There's a book here called The Mystery of Capital, and this is by Hernando de Soto. And what Hernando de Soto, he's an economist from South America, and what he says in his book, and it makes good sense, is that the reason that the West, and particularly the United States, is wealthy is because of our secure land title system. And he goes through a number of countries and talks about the unstable land title system, how banks don't loan on it, and how it's not secure as an asset. And his argument is that if you want to build wealth in the third world or in developing nations, one of the first things you need to do is secure land title so that people will borrow and develop and improve land. Interesting reading. Anyway, so as a land surveyor, we're directly connected and tied to this land and land title system. And we also get involved sometimes as experts in helping the courts understand the technicalities of land and land title. One of the things that I find troubling is I find land surveyors that get out of their lane. I'll give you an example. Land surveyor, I was checking some legal descriptions and plats recently. And on these plats, the surveyor showed, delineated a road, a dirt road, and it says easement by prescription over the road. So naturally, in my review of this document, I asked the surveyor for a copy of the adjudicated judgment by the court that developed or that gave this prescriptive right. And of course, looked at me, what are you talking about? And I'm like, oh my gosh. I mean, to think that a surveyor would impact somebody's property by putting a note on there that hadn't been adjudicated and opening themselves up to a slander of title like shows a fundamental lack of understanding of property rights. You can't impact somebody's property. They're entitled to due process. And in that due process means that there's an argument for that prescriptive right and there's an argument against that prescriptive right. If I have a right, if I own property, I do not want to grant out any rights without just compensation. Anyway, these things happen. And so I thought it would be good to run through legal theories just as a refresher to the land surveyors, and then talk a little bit about what our role is, because this wasn't a one-off. I've run into a number of situations recently where surveyors are making these proclamations. So let's get started. The California Constitution, Article 1, Section 1, I'll just pick it up in the middle there, and it says that acquiring, possessing, and protecting property and pursuing and obtaining safety, happiness, and privacy. It's written into our state constitution, and everybody recognizes the importance of property, and I would bet that every state constitution has similar rights to property. In law school, property rights are taught as a bundle of sticks. And I don't know this, I didn't go to law school, but I've talked to a number of attorneys and they explain to me how they're trained in this. And one of the things that they talk about is a bundle of sticks. Property is owned, the purest form of property ownership is fee absolute. And the minute you grant out a right, usually in the form of an easement, you no longer have fee absolute and you've diluted your title. Now, you may very well do this intentionally for compensation, but there's a lot of nuances in property rights. And then when these property rights are getting infringed upon or challenged, then there's legal theories. And a legal theory is just that, it's a theory, and there's elements that make that theory something you can present. Not you can present as a land surveyor, something that an attorney can present as an officer of the court and say that these elements are there and they're going to argue this theory. And then They advocate that, and ultimately a judge adjudicates that, or possibly a jury. Now, how does the land surveyor fit into this? Well, what Brown's boundary control and legal principles says is it says the surveyor has no authority to determine property ownership or property rights. The surveyor locates boundaries in accordance with and in relation to legal descriptions. That's true, but there is actually a caveat to that. You're determining ownership every day when you stake out or when you monument a property. You're determining the ownership of that property. It's when there's an adverse claim that the land surveyor loses that authority. If somebody disputes and says that's not the property line after you've set the monuments, well, basically your work is done at that point. You don't argue that that's the property line because you've monumented it. That's outside of your purview. Let's start with some of these legal theories. Adverse possession is one that most surveyors are familiar with. We're familiar with most of the elements: open and notorious, hostile, paid taxes, and a prescribed period of time of possession. Just know this, that adverse possession is a unicorn in the law. There's very few cases in California where this was actually adjudicated in favor of a plaintiff. I have an interesting story about this. A number of years ago, I had a real estate agent call me, and she was in a hurry to close a house, and something had come up as to a wall and a potential encroachment, or the eve of a house, I believe, was involved also. And so I said, well, I can help you out. I can come down and look at it. Well, a week or two goes by, I hadn't heard from her, so I called her up and I said, hey, whatever happened with that situation? She said, oh, we got it all resolved. I said, really, what happened? She goes, well, we hired a surveyor, another surveyor, and he came down and said, it's not a problem that my client owns that property by adverse possession. Even retelling that story practically throws me into cardiac arrest. And let's just be clear, no surveyor has the authority to make the determination of ownership through adverse possession, or any number of these legal theories I'm going to run through. Today we're going to talk about adverse possession, acquiescence, estoppel, laches, prescription, mutual mistake, necessity, and common report. And this is not meant to be, it's a 10-minute surveyor, so all I'm going to do is remind everybody what these actual theories are. I briefly covered adverse possession. I don't think I need to go into it any further. Just know that it's a very rare claim when it actually falls in favor of a plaintiff suing. Acquiescence is when somebody possesses the land of another or monuments the land of another and nobody protests, and over time rights may develop. But these rights that develop, a surveyor doesn't make that determination. So you lay out the west 50 feet of lot 1 and you see that there's it's been monumented incorrectly, or you realize that there's been a fence built in another place. And let's say it's been there for 20 years, 30 years. That doesn't change the title location being the west 50 feet. The surveyor doesn't say, well, that's the boundary based on acquiescence. What they do is they put in the boundary based on the evidence available, monuments. They show the relationship of the monuments to the title. And if those are different, then they would present that to the client, and the client would decide if they were going to pursue those rights with an attorney before a court. Estoppel. Estoppel is, the classic example of estoppel is the neighbor says, hey, I want to build a pool. And you're like, great. And they say, do you know where the property line is? I don't. He says, well, I'm gonna build the pool here. You say, great, I love that. They build the pool, and then you come back and say, thank you for building a pool on my property. It's on my property, I own it. No, you're estopped from, the argument is that estoppel, they may have developed a right in your property because you misled that individual. Again, you're never going to tell a client, well, you own that pool by estoppel. It gets argued before a court. Laches. Laches is similar, meaning it works, it's very similar. I believe they use the term laches attach, and what it means is it's very similar to estoppel, meaning you slept on your rights and somebody came in and you watched them develop something on your property, you never said a word. It's very similar to acquiescence. It's very similar to estoppel. These are all interrelated. Now, if you don't understand how these interrelate, probably best that you're not arguing these or presenting them to a client as to how they own them. And I don't know how these interrelate perfectly either. I don't need to know. I'm a surveyor. Easements by prescription, I told you my horror story earlier. And a prescriptive easement is a very expensive litigation. I've been involved in a number of cases where there has been a claim of prescriptive easements. Most of them fail, but some of them have went through. And you're not going to tell a client that you own this property or that you have access or a right to that property by prescription. What you're going to say is here's where the road is. I don't see any legal documents, easements, or anything that shows you that, and you need to talk to an attorney if you want to develop or argue that you have a right or interest in that adjacent property, that prescriptive right. Easements by necessity. The classic example is you have a road and you have a one property owner, and he subdivides the property parallel with the road and sells the property, and now it's landlocked. And he says, well, you can't drive across my lot to get to your lot. You adjudicate it and you make an easement by necessity. Again, a surveyor wouldn't say, well, of course you have access to this. You have an easement by necessity. That's not what a surveyor would do. Mutual mistake. They go out, they mark out the east 50 and the west 50 of the lot, and in doing so, they actually measure out 60. The deed says 50. They split the cost of a fence and a survey. Then they come to realize that they laid out the west 60. Okay, this is a mutual mistake, and that deed could be voidable, and it could be the west 60. Again, a surveyor is not going to make that determination. You could show the deed as the west 50, you could show the walls at 60, but you're not going to ever present a client with the idea that they own something based on mutual mistake. It needs to be adjudicated. Now, of all the things I went through here, I do have horror stories where surveyors are making these determinations, but one of the ones that I hear more often, I don't see that often, is common report as it relates to a monument. And so the surveyors will say, accepted as the northwest corner by common report. Well, it's suitable just to say accepted as the northwest corner as shown on map. But common report is actually a legal theory, and it can easily be debunked if the original monument turns up. So you have no reason to make a proclamation of common report. You can accept something, but understand that if the original corner turns up, or if there's evidence that that corner is somewhere else or that monument is somewhere else, then common report's gone. And so be careful. Don't make proclamations based on common report. Do your diligence, do a good job, and monument your corner as established by the evidence. But you cannot accept, or you certainly cannot, if two parties are adverse, you cannot tell them, well, this is your property corner based on this monument by common report. That is wildly inappropriate for a surveyor to say that. So I finish where I began. The role of a surveyor: you have no authority to determine property ownership or property rights. The surveyor locates the boundaries in accordance with, in relation to the legal descriptions. There's a caveat: you determine property ownership every boundary you establish. It's when there's an adverse claim that you no longer determine ownership, and people manifest rights in property, and you do not make that determination because you don't have the authority to make that determination. In closing, I'd say put away your clown shoes, pack away the mini bikes, realize you're not an adjudicator, and you have no authority to make these claims and settle boundary disputes. You do have the authority, when the parties are willing to sit down, to fix these situations by virtue of a lot line adjustment, in very narrow circumstances, a boundary line agreement, or writing an easement. These are all tools that a land surveyor has to resolve these issues. But we cannot represent a client or argue a point or adjudicate by a legal theory. Thank you for watching the program, and have a nice day.